slideshow done. Slide 2 is an overview of the presentation. The Deputy Minister has spoken to purpose and he has introduced the convention. And on the third slide, we will talk to the practices constituting a crime of apartheid and as prevented by the ISCPCA, the obligations placed on the state party, and why should we accede to the convention and the recommendation.
Chair, just to interrupt, Ms. Pillay, is Mr. Romano there or has he left us because just nothing's happening to this presentation? Oh, yeah, well, now it's gone entirely. But anyway, I just was asking if he, okay, no, it is now moving. But the issue was to have it as a slide, not as in its current format, because it is, yesterday Ms. Nivo-Drushin complained she couldn't read it properly, and then obviously for the slides to move. Thanks, Chair.
Thank you, Deputy Minister.
But maybe in the interim, Ms. Pillay can just carry on, because now I see they are trying, but they seem to be having problems.
Yes.
Okay, should I try flighting it myself? Oh no, I think we're fine now.
Yeah.
Okay, thank you very much. Thanks, Vanani. Slide 3 of the presentation. The purpose is to obtain Parliament's approval for the accession to.
Sorry, Ms. Pillay. I'm told that Mr. Leso is on the platform, so I don't know if you want. I don't know if you've seen him. If you want him to do the presentation. Okay,
Leso, is this the one you will do or the next one, the enforced disappearance?
DDJ, you can continue with the presentation. I can do the enforced disappearance.
Okay, thank you very much. Okay, thank you, DM and Chair. So the documents that were attached to the presentation, we are seeking first, again, Parliament's approval to accede to the convention in terms of section 231(2) of the Constitution. The documents that were attached is the text of the convention, the list of state parties to the convention, the legal opinion from the Department of Justice, legal opinion from DIRCO, the SEAS exemption certificate, and the letters to the NCOP chairperson and the speaker. Next slide, please, Vanani. The Convention on the Suppression and Punishment of the Crime of Apartheid, the Convention, as its roots in the opposition by the United Nations to the discriminatory racial policies of the South African apartheid government. The convention was adopted by the General Assembly on the 30th of November 1973 and came into force on the 18th of July 1976. There are 110 state parties to the convention as of the 24th of August 2022. The state of Palestine was the last to accede to the convention in 2014. Convention 1 declares in Article 1 that apartheid is a crime against humanity. Inhuman acts resulting from the policies and practices of apartheid are crimes violating the principles of international law, the UN Charter, and constitute a serious threat to international peace and security. Next slide. The accession to the convention is in accordance with South Africa's international obligations and other international instruments to which it is already party, such as the International Convention for the Elimination of All Forms of Racial Discrimination. It is aligned to the medium-term strategic framework priority 6, social cohesion and safe communities, and priority 7, a better Africa and world. Further, the convention is in line with Chapter 13 of the National Development Plan, Building a Capable State, the National Action Plan to combat racism, racial discrimination, xenophobia, and related intolerance, the NAP. The Promotion of Equality and Prevention of Unfair Discrimination Act, PAPUDA, and the department's strategic goal of advancing constitutionalism, human rights, and the rule of law. Next slide. Article 2 defines acts, practices constituting the act of apartheid as denial of the right to life and liberty of the person, of a racial group, through murder, torture, imprisonment, etc., deliberate imposition of living conditions calculated to cause destruction of a racial group or groups, preventing a racial group or groups from participating in the political, social, economic, and cultural life of the country, and deliberate measures to limit the exercise of basic human rights by a racial group or groups. Next slide. The Convention supports the implementation of the rights contained in the Constitution as it seeks to uphold and enforce the rights to human dignity, freedom, and equality. According to the offices of the state law advisors, that's the DIRCO and DOJ, the Convention is in line with our domestic law and international obligations. The accession will not have any financial implications as the UN treaty bodies are implemented and monitored through the existing state membership contributions. Therefore, there is a need to assert unambiguously that apartheid is indeed a crime against humanity and that practices associated with apartheid, racial discrimination, and other related intolerance will be punished. Should Parliament approve the accession, the Department of International Relations and Cooperation will deposit the instrument of accession to the United Nations. Next slide. We are on the recommendation slide. It is recommended that Parliament approves that South Africa accede to the Convention on the Suppression and Punishment of the Crime of Apartheid to Parliament in terms, sorry, I beg your pardon, Chairperson, accede to the Convention on the Suppression and Punishment of the Crime of Apartheid in terms of Section 231 of the Constitution. Thank you, Chairperson.
Thank you very much, Ms. Pillay. Members, any comments, questions of clarity? Honorable Neward Trojan, Honorable Ngola, Honorable Jele, in that order.
Good morning, Chairperson. Thank you. And good morning to everyone on the platform. Thank you for the presentation. I just wanted to know, I did see what the Honourable Deputy Minister said, but I still wanted to ask the question as I was reading. I thought to myself, and I asked myself as well, I wanted to know why at this stage in 2022, do we need to sign or assent to this treaty? It's, you know, over 100 other countries have already ratified it, including Palestine, I think in 2014, but South Africa has not yet. And yes, you know, there's an increase in the number of attempts to suppress other people, and racism does come up many times in this country still, but people still want to go back to the old days, like the old flag still persists, people still put it up. So I wanted to know why in 2022 we haven't, you know, why only now have we attempted to, or are we trying to assent to this treaty? Thanks, Chair.
Thank you very much.
Please, can you pin, please?
Honorable Maseko Jele.
Good morning, Chair, and good morning, members. And also thank you to Ms. Pillay for the presentation and the team. Good morning, DM. Chairperson, I think my question or my comments, you will pardon me if maybe okay, I'll show a sign of ignorance, or I don't know how to put it, but my question is that this treaty, it only talks to the dons. This is not supposed to be done. This is when it comes to apartheid as a crime to humanity. that our treaties that, for example, this one, it doesn't talk to the after. For instance, now, I understand that, yes, this should not continue. It should not happen. It has stopped in South Africa, but it has left legacy. It has left bad taste or division among the nation and also, those inhuman acts that were taking place. People died, families are left disgruntled, and all those things. These treaties, or this treaty in particular, it doesn't talk to how to rebuild. I'm saying, you will pardon me, Chair, if maybe I am ignorant in terms of how are these treaties done. But my concern, it is on the issue of after apartheid happened. How do we, I know that it is the issue of policies, but these treaties, how do they assist us in terms of that? Thank you, Chair.
Thank you. Thank you, Honorable Chair. Honorable Mola.
Thank you very much, Chair. I think let's first agree with the definition of what is an act of apartheid or the crime of apartheid. Equally, I think we fully agree with the fact that apartheid is a crime against humanity. The third aspect I wanted to review on is the fact that there are no financial implications, which in my view, I think there really can't be that much issues that we can disagree with assenting to the treaty. So I really wish to move for us as Parliament to support the assessment of the treaty. The final issue, Chair, I wanted to check is that, considering the fact that this is international law, how strong and effective will enforceability of the treaty be? It was as I think Honorable Levotrachen spoke about. Some will still see nothing wrong in displaying arrogantly apartheid flags. We know there are a lot of racial rents in the country, racial conflicts. Some of them are happening in the farms and all those things. So the issue that I wanted to check is, considering the fact that this is an international law, how strong will be its effectiveness and enforceability in helping us combat the crime of apartheid? Thank you very much.
Thank you very much, Honorable Mola. Honorable Deputy Minister.
Thanks, Chair, and thanks for the questions. Let me sort of answer them broadly, together. This treaty was adopted in the international struggle, or as very much part of the international struggle against apartheid. There was, I think, a UN special committee on apartheid that is referred to in the treaty. I'm not sure the reasons why it wasn't adopted before, but this administration feels that the fact that it wasn't adopted was a mistake. We should show our commitment, as the rest of the world did, to ending apartheid. Apartheid, remember, is more broadly defined. It's not just what happened in South Africa. It's similar practices which may be happening in other parts of the world. But the and then the other aspect is that this treaty unequivocally declares apartheid to be a crime against humanity. We had issues, I think it was about a year ago, where certain sections of the population were denying that apartheid was a crime against humanity. So I think that we unequivocally as a country need to put that to rest by saying no, as a country, apartheid was a crime against humanity. On Honorable Maseko Jele's point of rebuilding, no, because this was in the height of the struggle against apartheid, there isn't any focus on rebuilding, which is an important point that we need to look at. There are broader issues of post-conflict communities across the world. Some would be of broader value or broader issues. Some would be more specific to that country. Maybe one other point with the treaty is it's not just negative. Article 4, for example, is the state parties undertake to adopt legislative and other measures necessary to suppress and to prevent any encouragement of the crime of apartheid and similar segregationist policies. So there are some sort of positive aspects. The fact that it is broader, I think, is shown by the fact that long after the end of apartheid, as you would have seen from the list of countries that ratified, a number of other countries have been ratifying this treaty. Just looking briefly at the list, Guatemala and Honduras in 2005. As I said, the most, and Moldavia, 2005, Serbia in 2001. So, and then as I said, Uruguay 2012 and Palestine 2014. So, I mean, other countries are seeing this as an ongoing issue. The crime of apartheid, I speak under correction, but as far as I recall, it is contained as a crime in the international or in the Rome Statute, which set up the International Criminal Court. So it's already an international law, but this makes it more explicit that it's not just a crime, it's a crime against humanity. Thanks, Chair. I think I've tried to cover everything. I don't know if Ms. Pillay or any of the officials want to add.
Thank you, GM and Chairperson. GM Advocate Lugisa is online, Chairperson. She's the Chief Director, International Legal Relations. And there was a question on the effectiveness and enforceability of the treaty. Perhaps I can ask her if she's in a position to comment on that.
Just to save time, Ms. Pillay, maybe you can do that because we are under time constraints. The Deputy Minister would need to leave for another engagement, and we still have another treaty that still has to be dealt with.
Yeah, I think if Advocate Lugisa is having connectivity problems, I think Ms. Pillay, unless you've got anything else to say, I think that would be the response. She's posted that she's having, Advocate Lugisa's posted that she's having technical problems with connectivity.
Okay, there is a follow-up from Honorable Nebo Trojan.
Thank you, Chairperson. It's not really a follow-up. I just wanted to second what Honorable Mola has proposed, that we do support the treaty to be sent to the National Assembly for a session. Thanks, Chair.
Okay. Thank you very much. Deputy Minister, is there anyone who's going to answer the last question?
Sorry, what was that, Chair? Did I miss it?
I think it's the question that Ms. Pillay was supposed to answer, and then she referred it to somebody who had technical difficulties.
The impact of the treaty.
Yes.
Yeah, look, basically it is saying that South Africa accepts, as I'd said, that apartheid, or states that South Africa was a crime against humanity. Then, although as far as I'm aware, the Special Committee on Apartheid is no longer in existence, there are issues that can be taken up with the Human Rights Commission of the United Nations in Geneva. And there is provision for reports that was to the Special Committee on Apartheid, but we need to just find out from the Commission on Human Rights what the situation with that is. But otherwise, it is also particularly Article 4, adopting legislative measures, which we have to prevent or any encouragement of the crime against apartheid. And then I guess the other issue is its impact in the international domain. It hasn't, although there's a number of parties that are signatories to this treaty. It, as far as I recall, has not been brought up in the Rohingya, in the issue with the Rohingya. Palestine has signed up, but I don't know if they have brought up any issues relating to segregation in Israel and Palestine. So that's that would be my response.
Thank you very much. I've received a note that Honorable from the EFF is traveling, so she will not be with us, so that her apology can be noted. I'm not sure whether Honorable Swart has joined. Yes, I think yes, but I think he's attending the Chief Whips Forum. There is a seconder. There is a proposal for the adoption and seconded. Are there any views to the contrary? Honorable Maseko Chele, your hand is up.
No, it is not contrary, but I just wanted, for interest's sake, to find out was there or is there any harm if we within our ratification points, Chair, we insert the issue that I asked about it, or am I out of order? I wanted to find out, Chair.
No, with international treaties, you can't delete, you can't do anything. You must accept it as it is or reject it.
Okay, thank you.
But Chair, you may want in the report to the House to not so much, I mean, as you've said correctly, the treaty cannot be amended, but you may want to express, or the committee may want to support Honorable Maseko Jele's point about not that it should be in the treaty, because that can't be done, but the issue of what is also important is post-conflict, or looking at issues post-conflict.
Okay. Okay, thank you very much, DM. Honorable Breitenbach.
Thank you, Mr. Chair. Good morning to everybody. We reserve our position.
Thank you very much, Honorable Dennis Breitenbach. The Democratic Alliance reserves its position. So we will...
Morning, Chair. Morning, Chair. Swart here. My apologies for being late. I would also just need to study this more in detail. I just came online a bit late. Thank you also for noting my apology for the Chief Whips Forum a bit later. Thank you, Chair.
Thank you very much. Thank you very much. We will deal with the report maybe on Friday. I guess most parties would sit on Thursday and consult with their organization, with their caucuses, and we will adopt it or process it on Friday before we deal with the briefing on the drug and trafficking bill. Is that in order?
Yes.
In order.
Thank you very much. Can we go to the next treaty?
Thank you, Chair. I think Mr. Leso would be doing the presentation. The presentation needs to be flighted. Mr. Leso, last time it was done by the committee section. I don't know if you're in a position to flight it. Otherwise, if the committee section can put it on. But this one is a more recent treaty. It was negotiated, I think, in 2006. It's about the issue of its focus is on enforced disappearances. And enforced disappearance are the arrest, detention, abduction, or any other form of deprivation of liberty by agents of the state or by persons or groups of persons acting with the authorization, support, or acquiescence of the state, followed by a refusal to acknowledge the deprivation of liberty or by the concealment of the fate or whereabouts of the disappeared person, which place such a person outside the protection of the law. Now, as you know, so basically it is specifically state-linked disappearances. So a kidnapping by sort of people not linked to the state would not form part of this. I think as honourable members are aware, we had a lot of enforced disappearances in South Africa by the apartheid state, some of which have come to light through the TRC process. People who were arrested, people who disappeared. Some of the more high-profile ones would have been the PEP group of PEPCO activists who were abducted at the airport, taken off and killed. It was quite prevalent in the Eastern Cape. One thinks also of the Craddock Four were an enforced disappearance, which resulted in a killing pretty quickly, but a denial that had happened. The Pila Ndwandwe case, where at least the issue came to light during the TRC processes. They had abducted her from Swaziland. They'd held her captive on a farm outside Pietermaritzburg, and then they had murdered her when she refused to work with them. We've got other people who are still disappeared, who are unaccounted for. So it's still an ongoing issue. So we very much have been the victims of enforced disappearance. We've had victims of enforced disappearance in South Africa, and enforced disappearances are happening in other parts of the world. People disappearing, the state not acknowledging that they arrested them, and then concealing that they in fact arrested them, as the apartheid regime did. So, Chair, that's the broader overview. If then the officials can make the presentation. Thank you.
Thank you, Deputy Minister.
Good morning, Chairperson and members, and good morning to Deputy Minister, and thank you very much for the introduction. My name is Malesela Leso. I'm the Director, International Legal Relations in the branch Constitutional Development. I'll quickly be taking you through the presentation. Since the Deputy Minister has provided the background information, can we move to slide number 3, please? Yes, the purpose of the presentation, Chairperson and members of the committee, is to request Parliament to approve that South Africa accede to the International Convention for the Protection of All Persons from Enforced Disappearance in terms of Section 231, subsection 2 of the Constitution. Now, together with these presentations, we circulated those documents that are listed there to provide more background information to members of the committee. Next slide, please. Now, as the Deputy Minister has stated, this particular convention is a fairly new convention. It was adopted by the United Nations General Assembly in December of 2006. And South Africa was involved in the negotiations of the convention. And when it was adopted in 2006, we voted in favor of its adoption. Now, the convention is now in force. It entered into force as from the 23rd of December 2010 after receiving a requisite number of ratifications. Now, the other state parties are still welcome to accede to this particular convention as it is now in force. There are currently 68 state parties to the convention as of the 24th of August this year. Now, the reason we are moving with this request in Parliament to approve the ratification, the accession to this instrument, is that there were also calls from the international community, particularly from the Human Rights Council and other human rights committees urging South Africa to accede to the convention. But over and above that, accession will demonstrate South Africa's commitment to the protection of human rights and adherence to international human rights law. Next slide, please. The convention defines enforced disappearance as the arrest, detention, or abduction, or any other form of deprivation of liberty by agents of the state or by persons or groups of persons acting with the authorization, support, or acquiescence of the state, followed by a refusal to acknowledge the deprivation of liberty, or by concealment of the fate or whereabouts of the disappeared person, which place such person outside the protection of the law. Now, this particular treaty is the first universally binding international treaty that defines enforced disappearance as a human rights violation. State action is a critical part of what constitutes enforced disappearance, as per the definition provided above. Now, 5 key areas in terms of state obligations that arise out of this particular treaty is that the state should fight against impunity. It should undertake investigations and prosecutions of persons involved in this crime. The state should undertake measures for prevention and combating of the phenomenon of enforced disappearance. It should uphold the rights of victims and the rights of children, the abduction and disappearance from parents who have themselves disappeared. Next slide, please. Now, in terms of Article 24, sub-Article 4, it states that each state party shall ensure that in its legal system, that victims of enforced disappearance have the right to obtain reparation and prompt, fair, and adequate compensation, such as restitution, rehabilitation, satisfaction, including restoration of dignity and reputation, and guarantee of non-repetition of such acts. And this article does not necessarily impose an obligation on state parties to create a fund for compensation, but it provides or gives victims the right to approach any court to enforce their rights and seek remedies accorded by this particular convention. Next slide, please. Now, the convention is broad in terms of its protection and its scope. It emphasizes the protection of victims and the rights of family members of such victims. It incorporates many criminal aspects, which differs from other human rights treaties. You'll know about the Rome Statute of the International Criminal Court, the ICC. It also provides for enforced disappearance of persons as a crime against humanity. Now, you'll know that South Africa already incorporated the Rome Statute into our law by virtue of the ICC Implementation Act. Thus, in a way, the crime of enforced disappearance is part of our legislative framework. The ICC Act focuses on systematic and widespread fashion of enforced disappearance in the context of crime against humanity. But then this particular convention focuses on occurrences of enforced disappearance at a lesser scale or isolated individual cases. Next slide, please. So we say there's thus a little bit of lacuna or a gap insofar as enforced disappearance, which happen in isolation and does not necessarily meet the threshold of the crime against humanity. And that once this convention is incorporated into our domestic law, it will close that gap. Our law will have to ensure that enforced disappearance is regarded as an extraditable offense for the purposes of extradition and mutual legal assistance, as it is provided for in the convention. Now, the Department of Justice and Constitutional Development has undertaken widespread consultations with relevant stakeholders, including the offices of the Chief State Law Advisors at both the Department of Justice in terms of domestic law and in terms of our international law and international obligations. We have consulted with the Department of International Relations and Cooperation, Office of the Chief State Law Advisor. And those legal opinions have been provided to members of the committee, and they have indicated that the convention is in line with our domestic law, and it is also not in conflict with our international obligations in that respect. And we are indicating that should Parliament approve the accession, the Department of International Relations will deposit the instrument of accession with the United Nations through the diplomatic channels. In terms of the last slide, we are recommending to this particular committee to approve that South Africa accede to the International Convention for the Protection of All Persons from Enforced Disappearance in terms of Section 231, subsection 2 of the Constitution. Thank you, Chairperson.
Thank you very much, Mr. Leso. Members, any questions, comments? Honorable Nebo Dragons, followed by Honorable Jailer.
Thank you very much, Chair. And thank you very much for the presentation. I would just like some clarity. This convention talks about enforced disappearances. and enforced abductions. But I would like to know that, is this the same then as trafficking, as human trafficking? Because that also involves, the abduction, for example, the abduction of children. And we have seen a rise in this kind of crime, and it's a concern to people that, children are abducted. So, and women are also abducted in terms of human trafficking. So, does this instrument, does this instrument distinguish between, state-sanctioned enforced disappearances or criminal human trafficking abductions? We're also seeing a rise of business people being abducted for ransom. So how are these various crimes distinguished, and which ones fall under the treaty? If you could just clarify that a bit further in terms of this treaty and the criminal activity that we are seeing an increase. Thank you, Chair.
Thank you very much, Honorable Mr. Jela.
Thank you very much, Chair. And also thank you to, I didn't see but the presenter. Thank you very much for the presentation. I only have one question, Chair, but it is directed to the department. It's in relation to enforcement, the state enforcement. I just want to find out if these issues that are stated on this treaty that has to be done in terms of enforcement by the state in our country, do we have a team that is specifically dealing with those issues, or are we leaving this issue of disappearance only on the police and the Hawks? Because I'm talking about this, the treaty is talking about the people also those who disappeared within apartheid times, in those times, and many others. So I just wanted to find out from the department, do we have the specific team that follows this thing? Because to me, if we're going to have to leave this thing to only the police with the capacity that we have now, I don't see it us winning this a chair that is on the treaty, even if we support it. We support it, yes. Let me just say we support it, yes. But also, if I can get clarity on that issue, only, Chair. Thank you.
Thank you very much, Honorable Jela. Deputy Minister or members of your team?
Yeah, maybe just to start, just for Ms. Nivoet-Brushen, as we'd said in the beginning, this is about state or state-sponsored disappearances. So it would, abductions, and then the person disappears. There's no, somebody can get arrested, but then the state must acknowledge that they arrested you and give you access to lawyers and things like that. And enforced disappearance is if it's an arrest and you're gone. Human traffic generally does not involve states. It's more private bodies. Obviously, if it were to involve states, presumably they would not be telling people they have abducted people and then traffic them to somewhere else. But generally it wouldn't really be linked to human trafficking. And similarly, the crime of kidnapping, where somebody abducts somebody, if it's not done by the state or state agents or people associated with the state, it wouldn't be covered by the treaty. So it is very much the state's enforced disappearances. Look, somebody could get murdered, they've disappeared, but it's their body hidden somewhere, but it's by ordinary criminals, it's not the state, it wouldn't be covered. There is provision on children, but only, and that's Article is it 24, I think, 25, but that's only relating to the children of people who have disappeared, who've been subject to enforced disappearance, and what happens to those children. So it's specifically the issue of state repression. As far as then Honorable Maseko Jele's question, look, in terms of the post-TRC system, there is a missing persons task team that falls under the auspices of the National Prosecuting Authority. Officially, their mandate is to try and find people who disappeared on a list that was provided by the TRC. Sometimes in the process of looking for those people, they will find other people. And then there's a process which the Department of Justice is very involved in of exhumations and reburials, which is also funded by the President's Fund. So that is what is happening at the moment. It is, though, limited to people listed by the TRC. When this treaty is ratified, or if the treaty is ratified, we would have to look at our legislative provisions. Generally, Mr. Leso or Ms. Pillay can comment on this. The treaty would be taking effect post the ratification, so it wouldn't actually apply to the enforced disappearances from the apartheid period. But as I said, there is a missing persons task team, and they should actually come and brief you, Chair. I mean, they tell fascinating stories. They work with experts. I mean, DNA has helped them be able to identify bodies. Even I think it was with the PEBCO people that I mentioned, they were able to find fragments of their bodies in a tank. I think it was a water tank in the Eastern Cape through advanced DNA testing. But most of the body had been destroyed through burning, but they dumped what remained there. But they were able to detect some fragments of the bodies. So they would be, if you've got time, that would be useful for them to. It would be very informative for them to come and give you a input on their work. Thanks, Chair.
Thank you very much, Deputy Minister. Ms. Pillay and Mr. Leso.
Thank you, Chairperson. I will leave Mr. Leso if he wants to talk to further detail, but it may not be necessary. But I think this convention is different from the Apartheid Convention, where the clauses relating to that convention is defining what a crime against apartheid as a crime against humanity, whereas this convention does place certain responsibilities on us. The Deputy Minister has already mentioned some of the legislation. Should we accede to this treaty, we will have to amend some of our legislation in respect of children and enforced disappearances, amongst others. And I think it has other obligations, such as keeping a list of persons who are reported as being victims of enforced disappearances. So there is a lot to do about the implementation of the treaty post-ratification. Mr. Leso, I don't know if you want to add anything further.
Yes, Acting DG, just one element to confirm what the Deputy Minister was saying, that this convention does not have retrospective effect. So what it means is that our obligations will only arise after we accede to this particular convention. It cannot be used to investigate past crimes of enforced disappearance. Thank you, Chairperson, and thank you, Jim.
Thank you very much, Mr. Leso. Honorable Jele, is that a follow-up?
Yes, Chair. Thank you very much, Chair. If I may, I think, Chair, I would support the DM that we need to get a report on this matter of TRC missing persons committee to come and brief us. And Chair, I think we should also incorporate this information to the NPA team that is dealing with the issue of TRC. That's my proposal. If you can get them soon to come and brief us on, or when they come, if they can come with this information and this team and to brief us too. Thank you, Chair.
Thank you very much. We will look at the program. Thank you very much, members. There was, I think, Honorable Johans supported. Are there any comments? I'll take it that Ms. Breitenbach, Honorable Breitenbach, you reserve a position pending consulting with your caucuses.
That's correct. Thank you, Mr. Chair.
Thank you very much. So we will equally deal with this report on Friday before processing, but getting a briefing on the bill relating to what is the bill, drug and trafficking on Friday. Thank you very much. Thank you very much, Deputy Minister, Acting DG, Mr. Liso, and all other members of the department who had to prepare the presentation. Thank you very much.
Thanks, Chair. If I may be excused, and I assume the other officials who are not involved with your next item would also want to be excused.
Yes. No, thank you very much. You are all excused.
Thank you, Chairperson.
Thank you very much.
Thank you, Chairperson. Bye.
Thank you. Members, just before we go to Mr. Dupree, can we just deal with the report? Was it circulated, the issue of the salaries, was it circulated, Committee Secretary, did you circulate it to members?
Yes, Chair, it was circulated.
Okay, so it will be taken as read. Can we just quickly deal with the report on the salaries of the Public Protector, Deputy Public Protector, and Commissioners of the South African Human Rights Commission? Can you flight it? Report of the Portfolio Committee on Justice and Correctional Services on the draft notices determining the salaries and allowances of the Public Protector, Deputy Public Protector, and Commissioners of the South African Human Rights Commissions with effect from April 2021, dated 31st August 2022. Let's first deal with the corrections. Are there any corrections on page 1? Page 2. Can you go down? Page 2, page 3. Go down. Mr. Dupree, your hand is up.
Good morning, Mr. Chair. Good morning, members of the committee. I apologize. I know it's not my space to talk now, but in paragraph 5, there's a reference made to the Gazette, but it's not in italics. It's customary to use the italics for Gazette. Thank you, Chair.
Thank you very much, Mr. Dupre. It's a welcome intervention. Thank you very much for being alert. Is there a mover for the adoption of the report as corrected? Honorable Masepa Jala.
Chair, I move for the adoption.
Thank you very much. Any seconder?
Second,
Honorable Ngola seconds. Any objections? No objection. Thank you very much. The report is adopted. Can we have a 10 minutes break, a body break, and come back at 10:15 to allow Mr. Dupre to load his slides so that we can deal with the bill, the Land Court bill. Can we come back at 10:15?
Thank you.
Mr. Secretary, are you there?
Good morning, Hank. I'm here.
How are you?
I'm good, and how are you?
No complaints. Thank you. Can we just quickly test our share screen, please?
Go ahead.
Thank you. You've got it.
Yeah, no, it's fine. It's perfect.
Thank you very much. Thanks.
Welcome, members, and Mr. Dupree. Welcome back. We are now going to proceed with the processing of the Land Court bill. The department team is led by Mr. Dupree. Over to you, Mr. Dupree.
Thank you, Mr. Chair, and good morning to you and your members of your committee. If you will allow me just 2 minutes to apologize on behalf of the rest of my team members. Mr. Sabelemecha, my Chief Director, and Mr. Makudubete is attending other meetings on the regulations on the GBV bills, and they requested me to submit the apology for not being able to attend the meeting. Mr. Chair, while I'm going to go to the share screen because I would like to get to the bill itself, may I just ask, good grief, no, this is not it. My apologies, Chair. Mr. Chair, may I ask how much time do I have to present the working document to the committee?
You have until we should be in the house at 3, so we will process the bill until 2 to allow members to eat and go to the house.
Thank you, Mr. Chair. Mr. Chair, the document that we submitted yesterday, all the proposed amendments to the working document are highlighted in blue, but you will note, and as soon as we get to the long title of the bill, that I have marked some of the text in yellow. The reason for that being preparing for the meeting today, last night, I picked up a few additional aspects and I'll take you through that as soon as we get there. So with your permission, Mr. Chair, I'm going to dive right into it.
You can proceed.
Thank you, Chair. Mr. Chair, when we get to the long title of the bill, you will recall at the previous meeting of the committee approved or requested the department to remove the whole issue of the Land Court of Appeal or the proposed Land Court of Appeal from the bill, and that has taken much more of our time that we expected. And then also the issue of compulsory arbitration will also be removed from the bill for obvious reasons. But you will note that I've highlighted in yellow this part dealing with budgetary matters, and I will get to that later during the presentation, but I've highlighted it primarily for myself, Mr. Chair, just to ensure that this issue is included in the A list that the committee will eventually approve. When we get to the preamble, the only substantive amendment is as a result of a proposal that was made by an interested party who recommended that the preamble should also make reference to section 34 of the Constitution, and the department has previously conceded that it's a good proposal and that it can be done. The rest of the amendments in the preamble are merely of a technical nature, Mr. Chairperson. And then I am going to skip the arrangement of sections provision. However, there are many amendments there as a result of the fact that the Land Court of Appeal provisions will now be removed from the bill. So with your permission, Mr. Chair, and I'm going to scroll a lot today, but I would like to request the committee's indulgence in that regard. We will get to everything that we need to get to. I would like to then go to the definitions clause. Once again, the definition of claim. amendments are proposed there to maybe just clarify that whole definition relates to issues that arise under the Restitution of Land Rights Act, and then also with regard to the definition of claimant. Definition of the word day is to be inserted in the bill, also as a result of comments that we received, Mr. Chair, and that is for clarity purposes. Mr. Chair, you will remember that at the previous meeting, the concern was expressed that the SCA might be flooded by appeals. Now, the definition of court, we have inserted, or the definition of full court, we have inserted to say that full court means a court consisting of 3 judges of the land court. And this will also become apparent when we deal with the chapter dealing with appeals, but I'm just highlighting that to the committee at this stage so that we remind ourselves when we get to that chapter that there is a definition of what a full court is, because in that chapter we only refer to full court. Then this definition, or this proposed deletion, is obvious because of the fact that the provisions dealing with the Land Court of Appeal will be removed from the bill. And then once again here we are extracting reference to the Land Court of Appeal. With regard to the purpose and objects of the Act, once again removing reference to the Land Court of Appeal and then also arbitration. The rest of that clause remains the same. With regard to the establishment of the court, the proposed amendment now is to say that the Land Court is hereby established as a court of law, and in relation to matters arising from the application of the Restitution of Land Rights Act or any other legislation expressly providing therefore as a court of law and equity. The second proposal or amendment in clause 3 is once again as a result of comments that we received, and the department has conceded that it is more appropriate to refer to a superior court in line with the Constitution. With regard to the composition of the court itself, clause 4, no amendments proposed there, as well as with regard to the seal of the court and the seat of the court. Those are fairly standard provisions which we find in legislation dealing with the establishment of courts. With regard to the jurisdiction of the court, clause 7, once again, Chair, and I apologize, that was an oversight on our side, but I've highlighted this in yellow. We will give attention to that in preparing the A-list for the committee. So that is merely just to make sure that we don't oversee that once again. The rest of the clause remains the same. And then also with regard to chapter 3, the appointment of judges, clause 8, only the inclusion or the proposed amendment to insert the words in paragraph D, that reference must be made to the fact that the candidates for appointment must be fit and proper persons who are appropriately qualified, once again in line with the Constitution. With regard to clause 9, the proposed amendment here is more of a technical nature in order to avoid any confusion. clause 10, that is as a result of the Domestic Violence Amendment Bill that was promoted by the committee. This or a similar provision is to be inserted, was inserted in the Superior Courts Act. So it was necessary to also include a provision of this nature in this bill. With regard to the appointment of officers and staff of the court, there's not much, but I would like to highlight the whole issue. Unfortunately, there's not many references in this bill to his or her, but the approach now with regard to legislative drafting is to refer to non-binary language, Mr. Chair. So that is why we propose those amendments. With regard to the appointment of assessors, not much to report to the committee at this stage. Insofar as court proceedings are concerned, and this is now court proceedings, meaning the land court, the first proposed amendment here is once again switching to non-binary language, as well as the second. Subclause 2 is to be deleted because it actually states the obvious, and that was also as a result of comments that we received from interested parties. You will recall that we indicated to the committee previously that where reference is made to the responsibilities and obligations of the registrar of the court, it might be more appropriate for the rules to provide for those responsibilities. So the proposed amendment is merely to clarify that. And once again, paragraph or subparagraph B will also delete it as a result of the fact that it merely states the obvious. You will note, unfortunately, Mr. Chair, and that is what makes this bill an easy bill to amend, is that there are not many cross-references in the separate clauses, but we are amending or proposing to amend the correct reference then to the specific subparagraph. The rest of that clause I don't really need to highlight. It's more of technical amendments to be inserted in the bill. And then, Mr. Chair, this is very important, but I would like to highlight, we haven't highlighted this, or I haven't done it last night. This is a specific reference to the rules as they were issued in terms of the Rules for Courts of Law Act. So that is why we need to refer here to the, well, actually the provincial or local divisions of the High Court, because we refer to a specific set of rules that were initiated in terms of this act. But we also appreciated that it is not necessary to include the words that are highlighted in blue here. The proposal, therefore, is for those for that phrase to be deleted, because once again it is actually stating the obvious. And then, with regard to this clause itself, we do not need to make reference to the fact that, or to regulations. So that is why the proposed amendment is to delete reference to the regulations. And then subclause 3 is a proposed new subclause to ensure that there are rules available when parties go on arbitration before they even register a case with or a dispute with the court, to provide for when arbitration may be set aside by the court. So that clause actually comes from a provision that you will note later on that will be deleted, but it's necessary to include it here. And then it's merely a renumbering of that clause. Clause 15, dealing with the powers and the functions of the court and other legislation, that is merely to confirm that the jurisdiction of the court may be extended by other legislation. Clause 16, also as a result of comments that we received, and the committee has already had a look at the proposal. So it is merely replacing those words with more clear or a more clear indication that we refer to a person or a body with legal standing. The following proposed amendments are once again to move in the direction of non-binary language. On the powers of the court, Chair, those are also quite straightforward. The words that I'm highlighting now are the words that are in the bill as introduced. The double strike through and the double underlining, you may ignore. We've just kept it for purposes of the committee to see. Originally, we recommended or that those words be included in that provision, but now since the reference to arbitration will be removed, it's not necessary to. So all those words will in any event be removed from the provision. Judgment by default is also a fairly standard provision. With regard to part 3 of the bill, and I will get to this in a moment, but we are now of the view that the provisions of the Superior Courts Act is sufficient to deal with this issue. When it comes to witnesses, then once again, just a question of the registrar and their responsibility, not to be prescribed, but to be provided for in the rules. With regard to witness fees, once again, quite or fairly straightforward. We haven't included these words in the introduced version of the bill, but we are following the wording of the Superior Courts Act when it comes to witnesses. So in other words, we would like to propose at this stage that on account of youth or infirmity should be defined to the extent that it refers to old age or any disability. And then this is also a technical correction, Mr. Chair. And here we are with this provision dealing with this issue, which is already provided for in the Superior Courts Act. We are of the view that it's not necessary to include this provision in the bill. So we would like to propose that to the committee that this provision also be deleted from the bill as introduced. Insofar as the admissibility of evidence is concerned, there was a discussion in the committee that subclause 1 reference should be made to the Restitution of Land Rights Act, and we have inserted that. also specifically for purposes of clarity. When we come to, and you will recall, Mr. Chair, that since we are proposing that some of the provisions be deleted from the bill, a renumbering will also be necessary. So, and I'm not going to bore the committee with that detail, but renumbering will have to take place. Here, I've highlighted last night a reference to the Provincial Division of the High Court in the A list, the reference to the Provincial or the words the Provincial should then be deleted from the provision. The following proposed amendments is also just to conform with non-binary language. And then also here we have got reference to Provincial, which will be deleted by means of the A list. We've also got in sub 5, then of course the non-binary language, or the transition to non-binary language, as well as in the new clause 23. Then with regard to part 5, once again, Mr. Chair, the proposed amendment here is to rather revert to the provision as it is in the Superior Courts Act. So it is, strictly speaking, not necessary to repeat the provision in this bill, because we have a provision which deals with the fact that if something is not provided for in this bill, the provisions of the Superior Courts Act will apply. The correction here is with regard to the proposal that we received from the Land Claims Court, where they indicated, or where the acting judge president indicated, that it's not necessary to refer to pre-trial conferences, and it's more accurate to refer to conferences because they can take time at any stage of proceedings. With regard to the powers of the court, it's merely renumbering and also then a removal of reference to the Land Court of Appeal and replacing it with reference to the Supreme Court of Appeal, and that remains the same. The proposed amendment here also is a result of comments that we received, indicating that if the court has a suspicion during proceedings that corruption has taken place, that the court should be in a position to refer that suspicion to the relevant authorities for investigation. So this is the provision to be deleted because the provision in the Superior Courts Act will then apply. And then also replacing conferences instead of pre-trial conference, the provision to be deleted, the proposed insertion or inclusion of these provisions are more detailed and will be in line with similar amendments that will take place in the near future with regard to conferences. And if I remember correctly, and I apologize if I'm incorrect, Mr. Chair, and that's why I'm going fast, I think the committee has already received a document which reflect the proposed amendments in this regard. As far as court orders are concerned, a renumbering, and then also just technical language amendments. And then this provision, just to make provision for the fact that the court may also provide any other appropriate order. This proposed amendment here is to emphasize or clarify that the finalization of cases must be a constant consideration by the court whenever it issues an order. The remaining proposed amendments are technical. Not much to say there, Mr. Chair. Mr. Chair, I would just like to highlight this, and hopefully I'm not wasting the committee's time at this stage, but we have received a proposal that reference must be made to state land. But once again, and it won't take us long to determine that, but we would just like to go back to the 93 Act, because it might be that the intention of the legislature with regard to this subclause might be not necessarily to refer only to state land, but we have recently struggled with intermittent access to our virtual library. I was not able to check this, but once again, we'll be able to get back to the committee fairly soon on that. This is just a renumbering. And then with regard to the new clause 27, that's also merely actually a technical amendment for purposes of clarity. With regard to costs, we're only actually renumbering the clause. Under part 6 of the bill, the reference to arbitration will now be removed from the bill as per the committee instruction. These are technical amendments as well as a renumbering, but that relates to mediation, Mr. Chair. Reference then to arbitration will be removed from the bill. And then with regard to the settling of matters provision, I think it is also quite straightforward. I don't think we need to really belabor anything there. And then chapter 5, and this is maybe where we would like the committee's guidance. Instead of the Land Court of Appeal being introduced in the bill, it will be removed from the bill at this stage. However, one should then rather replace it with provisions dealing with appeals against judgments or orders of the court and other courts. And that will be an attempt to address the committee's concerns with regard to the SCA being flooded with appeals. Now, Mr. Chair, I'm going to pause here for a moment just to indicate to the committee what the proposal is at this stage, and that is for parties to decide whether they would like to appeal to a full court of the land court, that in other words, a full court consisting of 3 judges, very similar, well, actually a carbon copy of the existing system in civil appeals in the Superior Courts Act, where one can appeal from a single judge to a full bench consisting of 3 judges, or in the alternative, and it's up to the person who wants to appeal the decision of the Court of First Instance to the SCA chair. Just allow me a minute, please. My apologies, Chair. So the proposal here is, and this is the substantive provision now, which aims to give effect to what I have just explained to the committee, is to, in short, this provision then aims to provide a litigant to either appeal to a full court of the land court consisting of 3 judges, or then to the Supreme Court of Appeal. I think and the rest are merely consequential amendments to actually remove then reference to the Land Court of Appeal and to replace it with a full court, mindful of the fact that the aggrieved party will have the option of either appealing to the Supreme Court of Appeal or then a full court. Now we get to a few provisions, and I request the committee's indulgence so that I can just run through this. These are all the provisions that have to be deleted from the bill because they deal exclusively with the Land Court of Appeal, which is not going to be included in this bill now. I haven't highlighted this provision completely, but it's also to be deleted from the bill, Mr. Chair. And then when it comes to appeals from judgments or orders of other courts, like, for example, the magistrates' courts, the proposed insertion here is to provide for the rules to make provision for how those appeals should be lodged with the land court. When we get to general provisions, Mr. Chair, once again, merely in the proposed new clause 33, consequential amendments, the department is of the view that it's really not necessary to include this provision anymore in this bill because it is provided for in the Superior Courts Act. So that is why, and this is also something new, why the department proposes that this provision should then rather be deleted from the bill. With regard to transitional arrangements, a renumbering of the clause, the rest remains the same. These amendments are merely technical in nature as a result of comments that we received from interested parties. This provision, the committee has already also had a look at it. It was also a proposal from the acting judge president of the Land Claims Court to ensure that judges who are serving in that court at this stage will become judges of the land court. And then the amendment of laws provision refers to the schedule to the bill. our regulations provision will also be amended fairly extensively, merely or primarily to provide for those issues that the department is of the view that should rather be provided for in terms of the rules. Reference to arbitration to be removed, Mr. Chair. So primarily consequential amendments as a result of the instructions that the department received from the committee at its previous meeting. This provision, you will recall, we're taking it out here, but we're inserting it into that earlier provision of the bill. A reference to arbitration being removed, and then the short title and commencement provision to be renumbered, and then of course reference to the act number will now be replaced from 2021 to 2022. And then also in the schedule primarily, and in the schedule, Mr. Chair, most of these amendments deal with correcting reference to 2021 to 2022. They are not, and what the schedule primarily aims to do is to ensure that the reference to a court or the court should then be replaced with reference to the land court. So you will note that in some of the provisions, we propose that, for example, this is a good example, where it is proposed that a reference to the definition of court should be included in section 1 of the specific act to clarify that reference, or that the land court established in terms of this bill will then be the court to adjudicate matters flowing or disputes flowing from the specific legislation. The only real substantive issue that I would like to direct the committee's attention to is then, of course, and with your permission, Mr. Chair, I'm just going to highlight this so that we just check that cross-reference. The only substantive issue that I would really like to draw the committee's attention to is where, as a result of the instruction by the committee to remove arbitration from the bill, one of the principal pieces of legislation that are to be amended to ensure that the land court will have jurisdiction over hearing disputes flowing from that act refers to arbitration being referred to the land claims court, the judge president of the land claims court, in order to appoint an arbitrator. So in other words, reference to the judge president of the land claims court will then be replaced with reference to the Director General of the specific department. So that will, and I apologize once again, Mr. Chair, for doing this to the committee. I know it's frustrating, but I just need to get to that portion of the proposed amendments. So that we can just indicate to the committee what the intention is there. Oh, good grief. Mr. Chair, sorry, I'm just going to look for that substantive part of the proposed amendments in the schedule. I don't know whether you would like to hand over to your committee members to if there are any questions at this stage.
Can we give you 5 minutes to look for it, not being under pressure?
Thank you, Chair.
Thank you very much. We'll come back at 12.
Chair, it's 11 o'clock now. Here we are, Chair.
We'll come back at 11. Welcome, everybody. Mr. Dupree, I hope you have found that clause you're looking for.
Yes, thank you, Mr. Chair. These amendments, it's with regard to the Labour Reform, Land Reform Labour Tenants Act. As a result of the instruction that we received from the committee, we had to propose consequential amendments to that act, and it's item number 5 in the schedule, and I can maybe just explain the gist of the proposed amendments to the committee, and it relates to arbitration. So instead of those requests for an arbitrator to be appointed by the court at this stage, the proposal is then to replace reference to the court with the Director General of the specific department. So in the schedule itself, that is the most, or actually the only substantive amendments being proposed. I would like then therefore just to highlight the proposed amendments under item 5 for the committee's consideration. The remaining amendments proposed are merely consequential and mainly refers to just changing the reference to the Land Court Act as a 2022 Act instead of a 2021 Act. That brings me to the conclusion of the bill itself, Mr. Chair. You have mentioned, and I'm not, maybe I should leave it at that at this stage, Mr. Chair. I'll just go to the top of the document again with your permission. Thank you, Chair.
Thank you very much, Mr. Dupree. Members, that is the reworked bill, work in progress. Are there any comments? Mr. Honorable Horn.
Yes, thank you, Chair. Good morning from my side, and firstly, thank you, Mr. Dupree, for the hard work. It is quite clear that we're getting to the tail end of this process now. Chair, I have mostly a few technical issues or questions I want to raise, and then maybe one or two substantive ones. The first is, Chair, in respect of section 84A, as it now reads, I do believe it, unless I'm not reading it with understanding, that it's somewhat contradictory or self-contradictory. On the one hand, it says that these judges to be appointed must be judges of the High Court, but then in the very same vein, it says that at least half must already be judges of the High Court at the time of appointment. So I do believe that at least, depending on what the, I want to say the real aim is of the provision, it might have to be redrafted somewhat. If it is that that the intention is that judges of this court will be judges of the High Court, then I think the must just be removed. It may also be that it borrows from the current wording around the Land Claims Court, where we know there's secondments, which is also being dealt with in terms of the transitional arrangements. So I'm not quite clear from the reading of section 84 and 84A specifically, whether the intention is still that judges be seconded and some be dedicated judges of the Land Court. So I do believe that might have to be clarified and possibly redrafted, Chair. Then two provisions, 13.2 and 19.1.
Honorable Horn,
yes.
I think let's first deal with that one so that
okay.
I think
thank you, Chair.
Yes, then we can allow you to go to the other ones. Mr. Dupree.
Thank you, Mr. Chair. This is now exactly why I kept quiet after I've went through the bill. We've not only prepared the working document for the committee, but we've also got an A-list ready for the committee. So we might be at the tail end of business, and I would have wanted to maybe present the A-list to the committee as well. But Mr. Chair, we can certainly have a look at this portion of the bill. And it might be that the intention is not clearly defined here, but and it's for us to be guided by the committee. The message here or the intention is to ensure that judges that are appointed from or to the land court must at least half of that number of judges must be existing judges of the High Court. You will recall, if I remember correct, no, I don't think it was mentioned to the committee, but in the previous round of the JCS interviews, there were judges that were appointed to the High Court that indicated or that were requested whether they would be willing to serve as judges of either the Land Claims Court then, or then of course now the Land Court, and that is precisely for the reason to capacitate them. But let me highlight this in yellow. And with the instructions of the committee, we could have a look at the redraft of this provision. But I think and I don't want to prescribe to the committee, but I am sure that the recommendation from the department side would be to at least retain the principle that you have existing judges serving on the bench of the High Court to also be allowed or available for service to the land court. Thank you, Chair.
Thank you. Members, maybe for the purpose of practicality, can members for now, can I get members who would want to comment on this issue specifically, and then you would raise your other issues once we are done with this particular clause? Will that be fine, members? Honorable Neville Trochans. Honorable Neville Trochans.
Thank you, Chair. Just two things. I don't have anything on this specific point. It was other things, something else. So no, Chair.
Okay, thank you very much. Honorable Horn, are you responding to Mr. Dupree?
Yes, thank you, Chair. Yeah, look, I do believe there's a good argument to be made out that at least half of the component of the bench of the Land Court could then be judges that are seconded from time to time from other divisions. I see the logic behind it. My only point is that I don't think currently such a scheme is then properly reflected in the draft. So if we can just have a relook at that. Thank you, Chair.
Okay. Mr. Dupree, you will relook at this issue and then you will propose an amended draft.
Mr. Chair, I've previously lost a battle with the Honourable Member Horn. I would like him to make a proposal to me because it's quite clear to me what we're saying here, but it might be that I'm married to this provision.
Yes, no, I think Honourable Horn, maybe if you can also circulate your proposal.
Thank you, Chair. I'll do so.
Thank you very much. I think we are done with this clause. Honourable Horn, you are still on the floor.
Yes, thank you, Chair. Then the next two issues I have is really just, I think, because of the deletion of some portions where I believe then, from a grammar point of view, two sections do not read, I want to say, properly, and those are 13.2 and 19.1, where in both instances references to the prescribed manner is deleted. So if I may just suggest that I think 19.1 actually, I'm just re-looking at my notes quickly, Chair, I think has a better way of dealing with it, in the sense that it as a reference to provided for in the rules, since prescribed manner is then deleted. So my suggestion would be just that 13.2 be relooked along the lines of 19.2. But that's just a technical observation.
Yes.
Thank you, Chair. And then I have two other issues. The one is around mediation, which is actually also twofold. The first comment I want to make is that in 13.2b, it states that the judge president must decide immediately once a matter is enrolled whether it is to be referred to mediation. And I want to ask the department whether they have considered to what extent a judge president would be able to just merely on the initial enrollment documents to make a, let's say, a properly informed assessment as to whether mediation is the way to go. I know that there's I want to say a safety net provision, in the sense that later on in the draft there is a provision that it can also be done at any stage. But I would request that the department maybe just consider that issue. And then still on mediation, Chair, and we have sort of raised this previously, I would think that if the current wording around somebody who may be appointed as a mediator, which is limited to somebody who is fit and proper to be appointed in such way, is going to be the only guidance or the only regulatory framework for who is then to be appointable, that we must at least include something as well to the effect that the rules must with more specificity, more clarity or more accuracy, set out a framework as to who can be appointed as a mediator. As it is, we have our court annexed mediation and in magistrates' courts, which is of course voluntary. But when that was set up, I know that there was a system, or let's say firstly pilots, and then secondly it was determined that the mediation rules would be ultimately included as part of what was termed at that stage an advisory committee regarding norms and standards. So I would want to, I think the essence of my argument, Chair, is that the whole issue of just being fit and proper must be further regulated, specifically, Chair, and with that I conclude around mediation, because in South Africa, mediation is not properly regulated. So there's not one, let's say, state-endorsed regulatory authority. There's some or other authorities who actually non-profit organizations who claim to be regulating authorities. But the long and the short is that there's no proper regulatory framework in place. So I would just plead that we look carefully into that. And then the last issue I want to raise, Chair, just maybe a question, otherwise an argument that I don't understand why it's there. Chapter 5 and specifically Section 32 deals with orders which of other courts that may be appealed to the land court. But if I look at the jurisdictional aspects, I don't see any provisions that would ultimately enable such appeals. So I don't know whether this is just a broad provision so that ultimately other legislation can make provision for appeals to this court, so that this court then deals as a court of appeal in respect of orders of other courts. If not, I don't understand why it's there. And then the very last point I want to make is that Mr. Dupree indicated right at the start of his presentation that this bill is also to deal with budgetary aspects. Currently, it's of course not there. My only, I want to say, comment would be, is that whilst we're largely a technical committee in justice, the way I understand it is that there's very specific requirements around any legislation that deals with budgets and attempts to impose budgetary obligations on government, and that we will have to carefully look into that if the intention is to bring a further version that does include certain provisions that would impose budgetary obligations on government. Thank you, Chair.
Thank you very much, Mr. Dupree.
Thank you, Chair. Mr. Chair, the last question I'll answer first with your permission. We must take into consideration that we've got this existing court structure being regulated in terms of the Superior Courts Act. And this court, like no other, or like any other high court, will fall under the office of the Chief Justice. So in other words, the budgetary provisions are already there. And that is why it's not necessary to include a provision of this nature in this bill. Now you will note, oh yes, and then with regard to the question regarding the usefulness or not of clause 32, the question was actually answered to the extent that that provision is a general provision to provide for other pieces of legislation that will eventually direct matters or will increase or expand on the jurisdiction of the land court. So that provision is a provision that makes that provides for the future extension of the jurisdiction of the land court. On our screen, Mr. Chair, and that was the first proposal or concern that was expressed, is the wording, a period to be provided for in the rules. Strictly speaking, Chair, if you put it that way, you foresee something to happen in the future. In other words, you can implement the act can commence and we will wait for the rules. The bottom line, Mr. Chair, is that the rules must be available, must be in place before the commencement of the act. And then with regard to the qualifications of mediators, that is something that we can look at. One of two options, either a provision which is similar to the qualifications of persons to be appointed as judges to be included then with regard to mediators in the bill itself, or in the alternative then the rules. Thank you, Chair.
But can you repeat the last one?
Certainly, Chair. The proposal, the tentative proposal from the committee side then is to insert a provision that will require the rules to provide for the appropriateness or the qualifications of mediators to be appointed in terms of this bill. The alternative, which might be a suggestion from the department side, and I know that I have to respond immediately, one would like to think about it, is to possibly have a provision in the bill itself that deals with the qualifications or the appropriateness of mediators, and that is where I would like then guidance from the committee. But I might add, Mr. Chair, that mediators will be appointed by the court, the presiding judge, or not appointed. It will be referred for mediation. The parties will have an input on the specific individual. It will not suffice to send a dispute for mediation to a criminal law expert. It speaks for itself that you will send it to a mediator who has experience in, for example, land reform issues. And then with regard to, and I apologize, I haven't answered the first question yet. Yes, indeed, the judge president will not always be in the position to, from papers in front of him, be able to identify issues that might be referred to mediation, but it is still a possibility, and the whole or the reference thing to a judge as soon as the case appears before him to identify certain issues that may be referred for mediation is then a backup, if I may put it that way.
Honorable Horn, would you be covered if, for instance, in the Act, not in the regulations, what Mr. Dupree has just said, that it must be a person who is experienced in land adjudication matters, would that cover you?
Yes, Chair. I would also just want to advocate that we, in any event in the bill, make provision for that the rules may, let's say, further regulate who is deemed fit and proper to be a mediator, because that gives a bit of, I want to say, flexibility around the issue. But regarding somebody who's experienced, I mean, yeah, I don't want to be a devil's advocate here, but once again, that's a very fluid concept, or what I deem to be somebody experienced in respect of adjudication of land matters, and what somebody else deem somebody who's experienced in respect of those might be vastly different. But I leave it with Mr. Dupree. I think he understands my argument, just that some more the ability to strengthen the framework around who is appointable is something we must just look into. Thank you, Chair.
Thank you, Honorable Horn. I think we have dealt with all the issues. Mr. Dupree, are you fine?
Chair, thank you very much. Just maybe on the sideline, if I may, and please don't think I'm ignorant to the committee processes, but would you think that I've won this battle with Mr. Horn today?
He has raised many issues.
If I may, Chair, I don't know why Mr. De Pre sees this as a battle, but maybe someday when we are meeting in person, we can have that discussion about whether it's a battle or a cooperation. Thank you.
No, it's a cooperation.
Mr. Chair, sorry, I used the wrong word. No, anything to improve our products is always a positive step in the right direction. So I might refer to it as a battle, but in a jokingly way. Thank you, Chair.
Yeah, no, we understand. No, we took it in that spirit. Can you go to Honorable Nieuwort Drogen?
Yes, thank you very much, Chair. Thank you, Mr. De Pre. I was waiting for you to come back where you said you highlighted in yellow with regard to the budgets. You said you'll come back to that. So I'm not sure if you are coming back to it, but I'm not sure if you have answered Mr. Honorable Horn's point with regard to budget. I'm not sure if that was part of that. So I just wanted to check if that has been covered. And then secondly, appeals. Something I wanted clarity on. You said that a person who is making the appeal can decide whether to appeal or how they want to appeal. So I just wanted clarity with regard to that. I'm not sure if we finished with the matter on the appeal. Thank you.
Thank you very much, Honorable Nieuwort Drogen. Mr. De Pre.
Thank you, Mr. Chair. Yes, well, I'm standing under correction, but the question was raised why we should, what is the reason for removing the provision, if I remember correctly, it's clause. No, sorry, Chair, my clause numbers have changed, but the whole issue of the budget of the land court, my
Recording in progress.
Mr. Chair,
I was kicked out.
Yes, Mr. Chair, me as well. Let me start over.
I suspect it's Honorable Horn.
No, Chair, I was also kicked off. I don't know whether we were all kicked off, maybe.
We were all kicked off, and I suspect Mr. De Pre.
My technology knowledge is so advanced, Mr. Chair.
Okay, we can start off at the point where we are kicked off.
Yes, thank you, Chair. Okay, may I just ask that I'm allowed to share my screen again, please?
Okay.
But in the meantime, I can answer the question, and I've responded to the previous question regarding a provision specifically dealing with budgetary matters. Chair, I started off by saying that once this bill becomes an act of parliament and it's and it commences, must be read in conjunction with the Superior Courts Act. And this court, the Land Court, will in any event not be a separate individual court, but it will form part of the office of the OCJ. And that is where the budgetary implications come in, and that is where the budgetary regulations and statutory provisions are contained. So it will be a question of that there will be sufficient oversight with regard to budgetary matters of this specific court. And then with regard to the question dealing with whether a litigant will have an option either to approach a full court of the Land Court or the Supreme Court of Appeal, that is, if I remember correctly, the formula that is contained in Section 16 of the Superior Courts Act, which also introduces the principle that a person may, from a court of first instance, being a single judge, either appeal to a full court or to the Supreme Court of Appeal. And that is where the wisdom of, and I'm saying this on a personal level, Mr. Chair, I'm not necessarily saying that's the department's point of view, but that is where the wisdom of legal counsel will come in, to say we approach a full court, it will be certainly be cheaper, it might even be faster, or this is a matter of such extreme importance that we need to go to the Supreme Court of Appeal. But the principle is there that you will have the choice. The advantage of the provision, or let's say the choice of forum on appeal, is that the parties or the aggrieved person may decide which forum to approach, but it will, to a certain extent, introduce a filtering mechanism to reduce the potential caseload or the increase in the caseload of the Supreme Court of Appeal. Thank you, Chair.
Thank you very much. Honorable Nevot Dochans, are you covered?
Yes, Chair, I am. Thank you very much.
Thank you very much. Honorable Breitenbach.
Thank you, Chair. My issues were the same as Mr. Horn's about mediation, so I'm covered. Thank you.
Oh, okay. No, thank you very much. Mr. Dupree, will you take into consideration the issues that were raised by Honorable Horn? And I think Honorable Horn will also circulate his proposal to us and to yourself, so that when you come back, you would have made the necessary changes which we'll look at, and we can move to the next stage. Will that be in order, members? Okay. So, Mr. Dupree?
Chair.
Yes.
I'm actually ready to present my A-list to you today.
You're ready.
Of which 95% of it will be complete. It's only now to address those outstanding issues. But I would dearly love to take the committee through the A-list, or at least present the A-list to the committee. If the committee is, of course, satisfied with the majority of the provisions reflected in the working document, we can always highlight and just amend our A-list accordingly. But I appreciate that the committee is under time constraints. So I would like to, from at least the department side, to assist the committee as far as possible. The sooner we can get some work, maybe working in advance, and I know I'm not anticipating, or I didn't anticipate the committee's decisions, but I have an A-list available for the committee if the committee is interested in going through that today as well.
Members, can you go through the A-list today? Except the issues where we have flagged them, the issues raised by by Honorable Horn, the issues that are still going to be worked on, but the rest, can we go through them? Do I have a seconder?
Yeah, seconded, sir.
Sure. Thank you very much. Let's proceed, Mr. Dupree.
Thank you, Mr. Chair. Now, this is from a personal point of view, the boring part of committee work, because it's so technical. But we would like to indicate to the committee, and we apologize for not having submitted this document earlier, but it all depended on what happened in the committee this morning. But we have prepared an A-list in line with the working document that the committee has gone through. So with regard to clause 1, the proposed amendments are there. It is a question of just making sure that the A-list, the official version of the A-list then correctly reflects the proposed amendments by the committee. With regard to clause 2 as well, the technical amendments proposed there. Clause 3, the same issue. Clause 8, and please excuse me, Mr. Chair, I would like to ask my apology in advance. I can't remember the clause that we need to address the concerns that have been highlighted by the committee, but the proposed amendments will be inserted there as well. Most of the clauses, those are technical amendments and, of course, renumbering. All these issues I have highlighted to the committee when we went through the working document. Of course, the important issue is then also the exclusion or taking out references to arbitration. For example, then clause 21 will be rejected by the committee and not replaced by a new clause. And then from here onwards, there will be a fairly major renumbering then. So these issues are all, and then also, and I don't know whether I'm able to do this in an A-list, and I will be guided by the Bills Office and then, of course, the committee secretaries. One usually refers to clauses and not a part. But I think since an A-list is merely an instruction to the persons who prepare the final version or the B version of the bill, I think the instruction here will be clear, so there won't be any confusion. We will in any event proofread the A-list and the B-list as soon as they are available before they are made officially available to the committee members. So we will be alive to this issue as well. Then some of the clauses, for example, clause 26 will be rejected and not replaced by a new clause. Clause 27, the proposal there is to reject the clause because there are simply just too many amendments to be affected. So it might be more appropriate just to reject the clause and then to replace it with a new clause which will be renumbered as clause 25. And that's the whole issue of pre-trial conferences being replaced by conferences. Clause 28, mainly also those technical amendments, Mr. Chair. This is also, I was nearly tempted to also reject this clause or to propose that it be rejected because 19 amendments in a clause, it's actually a lot. So it's a lot of proofreading that one has to do with regard to that specific clause. Then the whole issue of reference to arbitration, those are the consequential amendments to ensure that arbitration or reference to arbitration is removed from the bill. Then clause 31, also quite a number of amendments, and once again 19 of them, merely primarily technical in nature. And then, Mr. Chair, I'm going to pause here for a moment and I'm going to come back to the whole issue of appeals. Chapter 5, and once again, we'll be guided by the Bill's office and the committee secretaries and the content advisors of the committee, but the proposal here is to reject the whole of Chapter 5 and then just to replace it with a new chapter, and that new chapter will only contain 2 provisions dealing with appeals against judgments or orders of the court, where one will then have the option of approaching a full court or the Supreme Court of Appeal, and the following provision is also then deals with in more detail then with regard to appeals, which have already been indicated to the committee earlier in the working document. And then in clause 49, we're merely replacing the heading of the clause. We're renumbering the clause and then also a technical amendment in that regard. Clause 50, if I remember correctly, is the clause dealing with, I think that's the finances clause that will be removed from the bill. And then with regard to clause 51, once again, renumbering and technical issues. Clause 51, which will now be clause 34, is the provision dealing with transitional arrangements, and this is the substantive part to be included in the clause in the working document. We've had a look at it earlier this morning, and that is the provision dealing with the existing judges of the Land Claims Court. Clause 52 will also be renumbered. Clause 53 dealing with regulations. Also, once again, Mr. Chair, too many amendments, in my view, to mention in an A list. So the department recommends that it might be more appropriate just simply to reject the clause and to replace it with an updated or refined clause, if I may call it that. And then clause 54 is the short title and commencement clause, which will be renumbered to 37. And then reference to 2021 will be replaced with reference to 2022. I don't think it's necessary to say or to refer in an A list to schedule to the bill. So I am most probably going to delete the words to the bill. And once again, since there are a number of amendments to the schedule, mainly those technical amendments dealing with replacing 2021 with 2022, the department recommends that it might be more appropriate or easier for everyone in the process just to simply reject the existing schedule and to replace it with a new schedule. Then, my apologies, I would just like to take the committee then. Of course, those blue highlights and everything we'll clean that up for the committee. And then we get to the introductory provisions of the bill that also need to be amended. The long title, I've already highlighted that in yellow last night because we need to remind ourselves that reference to budgetary matters must be deleted from the long title. With regard to the preamble, Mr. Chair, there's one substantive provision to be included in the preamble, and the rest are just technical amendments to ensure that our preamble reads consistently as far as that is concerned. And then also with regard to the arrangement of sections, or in other words, the index to the bill, also once again, and you may want to one day say it's because of the fact that the PRIA is too lazy to draft all those amendments. I think it's simply just easier to reject the index and to replace it with a new index. And that will then be the index of the bill as amended by the committee. And from 54, 52 odd clauses, the bill will then end at clause 37 and as well as the index. And sorry, Chair, I just want no, I think we're fine, but we'll double check everything before the committee is in a position to formally approve the A list, provided, of course, that we need to include the issues around mediators for the committee to consider. But, Mr. Chair, with your permission, I will prepare a separate clause and not a working document again, just to indicate to the committee where those proposed amendments relating to mediators will be slotted in. But the main object at this stage, I think, is for the committee to finally approve the A list. Thank you, Chair.
Thank you very much. So will you be done by Tuesday, because we are meeting on Tuesday to deal with the bill?
Mr. Chair, I will try my utmost best to be ready for the committee or on standby for the committee after the committee has received the briefing from the department on the drugs and drug trafficking bill. And if the committee still has time available, we could present it to the committee, but otherwise Tuesday is perfect. Thank you, Chair.
So you will be ready on Friday?
I'm going to try my utmost best, Chair. I don't know what's going to happen in the meantime on other bills that I'm working on, but I will try my best, Chair. So I will, let me rather say, I will indicate today is Wednesday. I will indicate to the committee secretaries at the close of business tomorrow whether I will be in a position to present to the committee the A list for approval. Thank you, Chair.
Will that be fine, members?
Yes, Chair, it will.
It's fine, Chair.
Okay. Okay, thank you very much. Thank you very much, Mr. Dupree, for your hard work. It's much appreciated. So if you indicate to us on the latest tomorrow, end of business tomorrow, we can say for now provisionally you are in for Friday, but if there is any change, then you will indicate. But definitely on Tuesday we are meeting as part of the program. We are meeting we are moving towards finalizing this bill. Honorable Horn, by when do you think your draft would be ready for circulation?
Chair, I'll do my best this afternoon in between the questions to finalize it, but maybe for safety's sake, let's say by tomorrow. Maybe just to get your guidance as well, do I provide it to Mr. De Pree or
yes?
Do I circulate it to? Okay, I will then engage with Mr. De Pree. Thank you.
Okay, thank you very much, members. I think we have come to the end of the meeting. We will meet on Friday. On Friday, we will be dealing with the adoption of the two treaties, and then we will be receiving a briefing on the drug and trafficking bill. And then if Mr. Dupree is ready, we will also deal with the land court bill. It will not be a long day on Friday. I think the issues are quite short, except the land court bill if he is ready on Friday. And we have just received another bill, the Maintenance Matters Amendment Bill. We will ask that it be circulated, and then we will, together with the committee secretariat, we will schedule a day of getting a briefing on this bill so that we can also advertise it for public comments. That is all, members. Thank you very much. The meeting is now adjourned.
Recording stopped.
department on the drugs and drug trafficking bill. And if the committee still has time available, we could present it to the committee, but otherwise Tuesday is perfect. Thank you, Chair.
So you will be ready on Friday?
I'm going to try my utmost best, Chair. I don't know what's going to happen in the meantime on other bills that I'm working on, but I will try my best, Chair. So I will, let me rather say, I will indicate to the trees on it.
Latest tomorrow, end of it to us. So if you indicate to us on the latest tomorrow, you are in for Friday. But if there is any change, then it's part of the final.
My best side
would be dealing with the one. It will ask that it be spoken. The meeting is now adjourned. Maintenance Matters Amendment Bill. We will ask that it be circulated, and then we will, together with the committee secretariat, we will schedule a day of getting a brief. All members, thank you very much. The meeting is now adjourned.